Rivers, he's the criminal lawyer.
Well, who is he?
Bruce Rivers, he's the criminal lawyer.
And who is he?
Bruce Rivers, he's the criminal lawyer.
And what he do?
And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, coming to you with my pearl-handled pistol cufflinks, so graciously gifted to me by my son and content genius, Michael Rivers. Today we are reacting to just kind of giving you what to look for this next week and a couple little updates on the Melly trial. But before we get to that, this is brought to you by eSign.com. eSign.com, a very effective way to remotely do business. So if your grandma's in your basement, she's got her own needle business that's really a mask for some undercover money laundering operation, and she needs to send out a bunch of documents. Well, what you do is you e-sign it. You e-sign it, send, sign, and you're done. I use it all the time. You download the app, you get 3 free signatures a month. It's a very effective way to remotely do business. So when your grandmother's downstairs doing her business down there and she's e-signing documents, give her a pat on the back, because it's an effective way to remotely do business, and her coming into the 21st century is what we need all people to do. You send it, you sign it, you're done, because if it's not e-sign, no one signs. Remember last week or whenever we talked about the possibly doing a field visit where the jury would go look at the vehicle. Now, if I'm the prosecutor, I really want them to do that, because it really gives you a bird's eye view. You know, you can get into the position where these people were, where this crime actually happened. The defense doesn't want that. And the defense doesn't want it because it's just more evidence of what happened. And you want to keep as much evidence of what happened out. So we're going to watch the judge, and we'll talk a little bit about what happened last week and what you can look forward to.
How about there's the state's motion for a jury review. We talked about that as well. That's supposed to be set for review. Still going forward on that motion?
So now it's the state's motion for a jury review. I have never had one before in 25 years. So these are extraordinary things. It really is not something that's done quite often.
Yes, Your Honor. The state would rely on the written motion and Your Honor's recollection of the testimony and argument that was made in open court as to how it would benefit the jurors. It is separate and distinct from the other items. In fact, the state would submit that the state could offer the entire car into evidence.
All right, I'm going to make a comment, and I don't normally do this, on what she's wearing. First of all, when you're in court, you really need to look presentable. And if you look at the woman on the far right, that's how a prosecutor should look, or any lawyer. You know, women wear skirts and different kind of clothes than men typically do. And that's the way you look. You know, see, if you look at her, it looks like she's wearing yoga pants and a sweatshirt. I mean, it just looks unprofessional.
Because it has been preserved, it has been in the same condition since it was initially put forth. And there is no limitations in the evidence code as to the size of the piece of evidence. If it doesn't come in through the courtroom doors, Your Honor, the state would submit that there would have to make arrangements for the jurors to be.
So the car is in its original condition. It means it's got blood all over it, and then they've got pictures of it, and so when the gravity of knowing what happened in that vehicle and feeling that by going in it and looking around in it can be pretty emotional.
To be able to view the item of evidence.
I did file a response, Your Honor. Were you able to read?
Yes, ma'am. I saw it. Anything else?
I would just add that we have yet to view the car ourselves. We're supposed to go see the car this afternoon after court. But as I set forth in my motion, I believe it's overkill. Her witness testified to the specs, the measurements in the car. We actually have photographs that have been moved into evidence that have measuring sticks that clearly show you the distance in the car. Her proposition that we need to see the car so they can see the purview, I guess she's planning on the jurors sitting inside the car, which makes no sense.
And here's the other thing. It's kind of a logistical nightmare for the court to have a bunch of jurors. And what are they going to do? She's absolutely right. What are they going to do? Are they going to sit right where the decedent sit? Or are they going to sit right where Melly sat? Are they going to sit right where Borland sat? I mean, they're going to actually sit in the car? I don't think that would be permitted, but...
Because they don't have the same measurements as the decedents. Moreover, I'd like to point out, we don't even know where the decedents were truly sitting because there are no crime scene photos that actually show them being in the car at the hospital. All the pictures that we were shown are of the decedents, the car being empty. So I would even argue the proposition of what she's trying to say, this person's sitting here and this person's sitting here. There's no actual evidence that that's how they were sitting.
All the more reason why it's important to be able to see the car and the defects therein, Your Honor. Counsel makes a great argument for
And I'd
that.
also argue it's a biohazard.
All the more reason you hear the counsel makes a great argument. That is like a snide little snippy comment that you don't need to make.
And so in terms of, there's never any indication that jurors would be sitting in the car whatsoever, so that would be inappropriate.
Then you make my point. We have enough pictures that have been moved in. It's
And she just went right back there. Then you just made my point.
which much of the theme of this case is overkill, being redundant. They don't need to see the car to get the understanding of the size of the car.
The defense lawyer just said the theme of their case is overkill. But you know, that's what prosecutors do. They go over and over and over and over things in order to get the message. And it's a standard tactic of an effective prosecution.
I think we got that with the measurements and the pictures.
Anything else for Will Don?
Yes, Judge.
Yes, sir.
Thank you. Respectfully, the motion tonight. I don't think it's necessary to have a jury review. I don't think it's essential. There's all type of photographs of the vehicle in question. I don't think it's going to assist the jury to any great degree in analyzing the evidence. So, respectfully, the motion tonight.
So he really didn't waste a whole lot of time because he knew he was going to argue or what he was going to rule before he even got on the bench. So that is the motion to have the viewing of the car has been denied. And I think that's probably the right motion or the right ruling. So now let's talk about where we at with this trial. What have we seen last week? Well, we saw there was an expert in ballistics. We had a medical examiner testify. We had Juvie's mom testify. And we had a gang expert and a T-Mobile expert. The gang expert and the T-Mobile expert are the two, probably one of the, aside from the medical examiner, really critical pieces of evidence. Because the T-Mobile puts Melly at the scene. If you can link that phone up to him, it puts him at the scene. That GPS data is really accurate. So what's next? We'll have somebody identify Anthony Williams. We'll have somebody probably talk about the cause of his death. Without there being an eyewitness, this is a circumstantial case, right? You're going to have to make some assumptions based upon use of that cell phone, that cell phone was Melly's. You're going to have to make some assumptions that he was in that car, but he didn't really get out of that car after the surveillance video. You're going to have to make and they can be very logical inferences from the evidence, but that's what you do with circumstantial evidence. The question then it becomes: will Mr. Henry testify? Will YNW Borland testify? And I know I have said all along that I really think he's going to testify, and I still kind of think he's going to. I'm really going to be shocked if at the end of the day he doesn't testify, because the defense theory is that, look, the guy who brought him to the ER and the guy that lied about it is probably the guy that did this, but they know he drove, but where is his involvement in this? And he's going to have to look out for his own ass. I would be shocked if he doesn't testify. But at this point, if they don't think, and here's the other danger of actually having him testify for the state. He's already lied. He's already created this big story that didn't exist. And the defense or the state's case is all based upon the fact that the drive-by didn't happen, that was a complete lie, and that Henry lied when he went. So how does that make him a good witness? it makes him a very terrible witness because he's already lied about a murder that happened and was covering it up for Melly, right? So it'll be interesting to see if he does in fact testify, because he's got baggage that makes him a bad witness. I would think that his lawyers would try to strike some kind of deal, knowing the strength of the state's case, especially because it's stronger against Henry than it is against Melly. Why is that? Because he's the one that delivered the bodies to the ER. And so the way this works is the state has the burden of proof, so they go first. And so then what will happen is the defense will put their case on, and that'll take a long time. But here's the thing. After the defense rests, the state can put on rebuttal witnesses. Rebuttal witnesses are witnesses that come after somebody testifies, specifically related to what the testimony is for the defense. Okay, so they can't just kind of relitigate their whole case in a rebuttal. It has to be related to specific things that the defense has brought up. So we'll continue to follow it, and we'll see you next time here on Criminal Lawyer Reacts. Make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, and we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away.
23-hour lockdown, please, is that my God?